Now for what's tipping the scales of justice, the state's expected to rest today when the surgeon strangles wife. Murder trial resumes at 10 a.m. Eastern time. Defendant Dr. Ingolf Tuerk could be taking the stand as early as tomorrow. He's accused of killing his wife, Katie McLean, after the two of them got into an argument after a night together of drinking. Now, she was last seen on May 14th, 2020 at their home, and her body was found some days later in a pond after Tuerk eventually told police where he had left her.
We're going to go find her. And we can get through this. We can get through this. I know this is going to be difficult. There's no way getting around it. We can't leave her out there alone, Harry. We can't. We can't do that to her.
So the defense team here doesn't deny that Tuerk killed his wife. They're acknowledging that he did. But what they're saying is this wasn't a premeditated murder. They're saying that this was something lesser. So it's all about intent at the time. So could his testimony tip the scales? Let's bring in our guests. Still with me, Charles Middlestat and Michael Sterling. Okay, Charles, let me begin with you. You are a tremendous defense investigator. That's what you do, dig in for defense teams and give testimony at trials. Here, I'm sure they've got a Charles Middlestat up in Boston who worked this case with them. What do you think? Do you think this is smart for Dr. Tuerk to get up there and walk the jury through the process, how things got to the fatal incident?
In terms of him testifying in his own defense?
What do you think?
I mean, I think it's always risky. You know, you have great defense lawyers that do all this great lawyering and make great arguments and suppress evidence and you know, do the real heavy lifting. And then when a defendant elects to testify in their own defense, literally all of that is gone. It's all the work, and it really just comes down to one thing, whether the jury believes the defendant or not. And so the defendant ends up assuming single-handedly the entire burden for their defense in doing so. And so that's always a very, very difficult decision. It's obviously a decision that counsel advises for or against, and sometimes, and you know, I've been a part of many defense teams where defendants have just been insistent on testifying. They want to be heard, and they don't take advice of counsel, and it has generally not worked out in their favor.
Right. Yeah. Sometimes they.
Sometimes it's the only way. There's no other option.
Yeah.
Sometimes they have to testify.
Sure.
But it's perilous.
It's right. I know. I always say they rarely help themselves. But Michael Sterling, what do you think in this case? He's talked a lot already, as we know. He gave a lot of interviews with police, walked everybody through it. What would you advise him?
See, I would say don't take the stand, right? Typically, if the prosecution is going to let my client testify without being subjected to cross-examination, which is the body cam, the interviews, anything you've done, he's already said enough. So you've already given your version multiple times. There's no point in putting you on the stand and subjecting you to cross-examination when you were able to actually tell your part of the story without taking the witness stand.
Sure.
So typically, if I have that kind of evidence, I won't put my client on the stand. And sometimes, you know, to Charles's point, there's a jury instruction that says one witness, if believed, is sufficient enough, right? So you wonder, once your client takes the stand, everything else goes, it goes out the window. And I tell my clients, if you want to take the stand, the case is now out of my hands and it's in yours. What you do is going to determine what this juror comes back with. Right? So it's not on me anymore. Now it's on you. You're the star, not me.
Right.
And so it is a very risky proposition, especially in a case where you're basically admitting guilt but trying to get the jury to mitigate, right? And typically in a self-defense case, my client may take the stand, right? Because
Cornisha Johnson, that case we broadcasted,
right? And the juror split it, right? The juror said, we kind of believe her. So the prosecution was saying, hey, this was premeditated. She went in her house intending to kill him. She says it was self-defense. And the jury came back and said, we believe her sort of, right?
Right.
So they gave her the lesser included.
Right. So that's a win for you, not getting murdered.
The jury's unlikely to really like him just based upon the fact that he puts his wife in a pond, right?
Right.
It's one thing if, in fact, you know, this was a unintentional act or heat of passion sort of thing that was not premeditated and it resulted in a tragic death. But to then take the next step to actually conceal her body and put her in a pond and all that, that shows deprivation. That's something that a jury's not going to like, and that's something that he will have to answer for in cross-examination.
Right. Charles, I'm so glad you brought that up. I think we have time to play this quick clip from the medical examiner when we learned about the rocks that were put inside her pants to weigh her down. Take a look.
Is this one of the rocks that was in Katie McLean's pants when she was brought into your office?
Yes.
And do you recognize this as the other rock that came out of the pants of Katie McLean?
Yes.
Ooh, so that was a moment, as you both know. Charles, you know, to your point, if this was just a heat of passion kind of thing, the guy's a doctor, right? He could try to save her, give her, you know, CPR, but no, he takes the pond route.
Just consider for 1 second what that would be like for a human being to literally stuff rocks in the pants pockets of someone that they presumably loved, right? That's, again, that sort of deprivation, emotional deprivation, detachment that is so callous that that's hard for a jury to sort of get beyond that and have any sort of, you know, favorable or objective consideration towards this defendant.
I think you're right. That was a moment. It stuck with all of us, and I bet it stuck with that jury. Michael, tell me, when it comes to like moments, we were talking off camera, you never know really what a jury is going to do. You know, and quickly with this one, do you think that at the end of the day, the jury could possibly find that this was something less than murder?
I think it's going to be tough, right? Because, you know, your actions after have a lot of effect on what the jurors did, and this does make it look intentional, right? Those rocks, hiding the body, doing those things afterwards, the jury can't consider that.
Yeah, I think you're exactly right. We've got to leave it there just for the time being.